Okay, well, let me welcome our next speaker, who some of you may already know, and it's Simon Maybury from ACAS. Simon is going to talk to you about legislation which is going to affect all employers and employees, so an update with that. And also, I have to say, he's a great resource, and he's going to be outside, just outside here. He's got lots of brochures from ACAS. And if you have a specific issue that you're dying to discuss with somebody or get some advice, you know, here's your person. So do use him at lunchtime to catch him, to talk things through or to get some specific advice. So I'll pass you over to Simon now. Thank you.
Thank you, Patricia. Hi, everybody. I work in ACAS, East of England, which does cover Hertfordshire and Bedfordshire. So today's a good opportunity for me to come and speak to people. So thanks to the LMC for that. ACAS's role, clearly I'm going to talk about employment law. Our role is actually about employment relations or good practice. And it was quite interesting at the beginning. Peter asked a number of questions and almost challenged people to sit down if they had a full understanding, amongst other things, of employment responsibilities. Now, I'm sitting on the front row here. I'm not sure how many people sat down. Didn't seem like too many. A couple of points about employment responsibilities. Two groups of people really affected here. One, employers, and I think in your sector that will often be the partners, okay, the GPs. Two, managers. That's obviously you in the room. Now, I have done some work previously, in previous years, through the BMA, and I am aware of the nature of the dynamics between partners and practice managers in terms of managing employment relationships. Usually it's good for me to have the opportunity to speak to employers as well. Okay. What I'm going to cover is a quick summary of employment law. Now, it is a summary. I'll outline the key points on the slideshow, and I will be available for any specific questions afterwards. Okay? A couple of points about employment law. First of all, there's a lot of it. Okay? Since '97, when the Labour government then got in, there's been an increasing amount of it. And the second point is, at the moment, there's a lot of proposed changes to the system. Okay? So I've been sitting on the front row thinking, in the GP community, you've got quite a lot on your plate at the moment, haven't you? Another thing you've got on your plate is dealing with the impact of a lot of this change and proposed change. Okay? Right. Consultation on modern workplaces. Some of you may be aware of this at the moment. I don't know how many of you access the Government Department Biz website or DirectGov website. These are proposals at the moment. Consultation has finished. Flexible parental leave, very quickly. There's a proposal to replace the existing arrangements for maternity and paternity and adoption leave with a system of flexible parental leave. Now, that's proposed to come in 2015, so it's a little way off. Very quickly, the proposals they're looking at are to retain a period of 18 weeks paid maternity leave, specifically for the mother. After that period of 18 weeks, there'll be a period of 34 weeks entitlement to leave, which will be shared between the mother and the father or the partners. There's also talk at the moment that 4 weeks of that will actually be designed for each parent to take individually. And then the remaining period will be split between both parents or both partners. Okay? Part of that extra 34 weeks will have an entitlement to be paid, part of it won't. So I'm sure most of you are aware at the moment, statutory entitlement to pay with maternity extends to 39 weeks. So after 18 weeks for the mother, the period of leave that will attract pay to be shared between both parents will be 21 weeks, okay? I think we're going to have to wait and see what happens with this. Some of you may be aware at the moment we do have an existing system of parental leave, but it's not the same as this proposal, okay? Because the existing system of parental leave is up to 4 weeks per year of unpaid leave, okay? Now, there are some proposals to tinker with that, which were originally due to come in this year. They're now postponed for next year. Something else to keep your eye on, flexible working. That should say the right to request flexible working. One thing we come across in ACAS when we speak to individuals and employees is they conveniently forget the right to request bit. They think it's an automatic right to have it, okay? This proposal's quite easy to cover. At the moment, the right to request is there for people who have responsibility for care of children up to 16, or responsibility for care of an adult. Now they're proposing to extend that right. How far do you think they're proposing to extend it? To everybody, okay? Oh, that got a cheerful response, didn't it? We seem to have had quite a few of those this morning so far. Little intakes of breath. This is a proposal, and remember, it's still a right to request. As employers, as managers, there is the right to turn down a request, okay? Working time regulations, proposal at the moment is to take into account recent case law, which covers the rights of people who are off sick for an entire leave year. And case law has established they're still accruing their right to statutory holiday, okay? So the proposal here, which isn't enacted yet, but it looks like it might come in next year, is to give people the statutory right to carry over leave if they're on sick leave for an entire leave year. Now that carryover at the moment is confined to 4 weeks, okay? But again, watch this space, and there's quite a lot of case law going on about this. So how this will be managed will give you extra responsibilities, I think, okay? That's a nice way, of course, of saying give you extra headaches. Equal pay, this is already in. And basically, this now gives the system the power with equal pay cases where an employer is found to have breached equal pay regulations. It gives the system the power to impose an equal pay audit onto that organisation. Okay? Still, that's obviously not going to be a concern, is it, equal pay? Next slide, please. Right. At the moment, we already have additional paternity pay and leave. Now, it's usually at this point, I say to my audience, it's already in place, it's been there about a year, and I invite you to say to me, we're already up to speed with that completely, Simon. Thank you. And we'll flick on to the next slide. No? Okay, I'll summarise it quickly then. This is what the flexible parental leave is proposed to replace, but this is in place at the moment. Now, this affects the rights of a husband, partner, father to take additional paternity leave on top of the original 2 weeks paternity leave, depending on how much maternity leave the mother takes. So the maximum entitlement for maternity leave is, any guesses, how many weeks? 52, good stuff, okay. Some mothers come back before 52 weeks. Potentially, they could come back after 26 weeks, in which case the father or partner could get additional paternity leave up to 26 weeks. Some mothers will come back after 39 weeks. Why do some mothers come back after that period of time? That's when the pay runs out, yeah, which motivates most of us, doesn't it? Okay, and in that situation, we'd be looking at 13 weeks extra paternity leave for the father. So that's the system at the moment, okay? We could flick on to the next slide, please. Yeah, no worries. Yep, it's bad timing on my part. Right, okay, a few other things, updates at the moment. These all came in April this year, so it's recent stuff. Some of this is quite technical. After the Equality Act in 2010, they've had to make an amendment to define an independent advisor for compromise agreements. Compromise agreements, that's where there's a legal dispute between employee and employer. Compromise agreement is a way of settling that dispute. As it stands, or as it stood, that compromise agreement needed to be supported by professional legal advice. Now, after the Equality Act, there was some doubt about whether somebody who had supported or represented somebody bringing a discrimination claim would have the power to act as that legal advisor for a compromise agreement. That's just been clarified now that they do have that. As an ACAS advisor, I must point out there's an alternative to compromise agreements. Because guess what? Legal advice costs. There is the possibility of an ACAS conciliated settlement. Okay? So I appreciate I'm doing a bit of double glazing selling here. ACAS conciliated settlements are free of charge. Okay? Qualifying period for unfair dismissal. In April, that increased to 2 years. Now, this is the bit of the presentation you're supposed to cheer, because it's gone up from 1 year to 2 years. Okay? So this is one of the measures introduced by the new government, which is aimed at being more business and more employer-friendly. However, this 2-year qualifying period is only for people who were recruited after the 6th of April. So if you had somebody recruited on the 4th or 5th of April, they still have 1 year qualifying period. Okay? Now, of course, good employment practice is you don't have to worry about this because you don't have the need to dismiss people too often, and when you do it fairly and reasonably, so they don't go off to tribunal. Changes to employment tribunal procedure, it's a little bit technical this. Some cases the system will require a deposit from the parties to go to a full hearing. Now sometimes that's to do with the sort of preliminary arrangements, sometimes it's to do with the system's view of the quality of the case from either side. That deposit is raised from £500 to £1,000. Also, an increase in the top level of costs that can be awarded. Costs can be awarded by the employment tribunal system against either party. Okay? I'd have to say it's rare, but it does happen. Upper limit is now 20 grand. Okay? Suspension of Sunday trading rules. Not sure it particularly affects you. This was something that was put into place for the Olympics. Really affects businesses and retail. Next slide, please. And the next. Right. A few other developments. Now, this is under the Enterprise and Regulatory Reform Bill, proposed to come in at different times. Early conciliation by ACAS. Not sure if anybody's heard of this. I've mentioned ACAS conciliated settlements. We already provide a conciliation service. That kicks in when somebody lodges a tribunal case. What they're proposing here is that before people can go to tribunal, they must go through early conciliation with ACAS. Now, that's proposed to come in April 2014. It's an opportunity for ACAS, actually. It's an opportunity to intervene and help with dispute resolution and prevent parties going to expensive, time-consuming, disruptive tribunal cases. Part of the proposals we're looking at the moment is that people would have a 1 month sort of suspension in terms of the time limit to go to tribunal, to give early conciliation an opportunity to work. Changes to the EAT, that's Employment Appeal Tribunal. I think the only change here is they're talking about the option of a judge hearing that alone, not with side panel members. Financial penalties on employers. All right, this could be quite interesting. It's proposed to come in next year. Whether it will or not, you're going to have to keep an eye on it. But it's talking about a penalty on top of any award that an employer has to pay if they lose a tribunal case. Now, what do I mean by award? That would be the Unfair Dismissal Award or Wages Act, compensation, so on and so forth. And they're talking about potential penalty on top of that for what they call aggravated or aggravating features. It remains to be seen what aggravating features are going to be defined as. But, employment law is based on principles of an employer acting reasonably and fairly. And that can be applied in all sorts of ways, whether you're looking at discipline and grievance, absence, requests for flexible working, so on and so forth. So I think my guess would be an employer who can't demonstrate that they acted reasonably at all and then behaved in a certain way at tribunal could be subject to a penalty. That penalty is proposed to be up to £5,000. Okay? Some tribunal claims to be heard by legal officers rather than judges. After consultation, I think that proposal's been dropped. Whistleblowing. Now, most people have heard of whistleblowing. Is that the legal term? No, it isn't. The legal term is Public Interest Disclosure Act. That's where whistleblowing came from, okay? And it's intended to protect people who blow the whistle on the practices of their employer or their organisation. One of the requirements, as far as I'm concerned, was always that the issue they raised was in the public interest. There's concern recently that some employees are merely whistleblowing breaches of their own personal rights. Now, all this proposal is saying we need to go back to the original intention of the law and reinforce it. Okay? Quite often at this stage, I'll ask for a show of hands who's had to deal with whistleblowing in their organisation, but I'm not going to do that here. Be a touch unfair, I think. Okay? Right, next slide. Thank you. A couple of things from the Enterprise and Regulatory Reform Bill. Again proposed. So there's a lot of stuff in the offing, isn't there? And it's the next year or two, I think you're going to have to keep a close eye on some of these proposed changes. Okay. Settlement agreements. That's what I've just referred to as compromise agreements. So there's a proposal to rename them settlement agreements. And there is a call for evidence in terms of trying to give employers and individuals the facility to open discussions about a settlement agreement under protection. So that means that those discussions wouldn't necessarily compromise your defence as a manager or employer if it didn't settle and went on to tribunal. Okay? So that's something to look out for. changing the maximum limit of the compensatory award in unfair dismissal claims. Who could give me a rough guess what the current limit is? 52? 60? Getting closer. It's about 72 grand. However, that's rarely paid out. That depends on the individual's actual losses, okay? The average is something like 5 or 6 grand. Proposal here is that the upper limit's too high, and what they're talking about is exploring whether the upper limit should be restricted to 12 months' pay for the individual, okay? Of course, from an ACAS perspective, good employment practice, again, you shouldn't have to worry about unfair dismissal awards too often. Okay, other proposals. Some of these are very popular. TUPE, Transfer of Undertaking Protection of Employment. Who's had to deal with the TUPE issue in their time? Oh dear. You have my sympathy. Heartfelt sympathy, okay? It's a very complicated part of employment law, although the principles are quite simple. The principle is transfer of ownership, which could be a purchase of a company or organisation by another, but it can also be transferring a service, a contracted service. The workforce affected, their employment rights are transferred to the new employer. Therefore, the new employer picks up the employment responsibilities. That sounds simple, doesn't it? Defining it against real-life situations is horrendously complicated, okay? And solicitors make quite a good living out of trying to define and argue disputes. Now, the proposal here is to try and clarify and simplify the guidance about interpreting the law. My comment as an employment advisor is good luck to them. It's going to be tough. Consultation on collective redundancy. So that's redundancies of more than 20 people in the same period. At the moment, statutory consultation period of how many days? 90. Quite a few parties and lobbies think that's too long. It's a proposal to bring it down to 45. I think it's likely to come through, I think. But again, need to keep an eye on it. And interestingly, it's not just employers saying it's too long. Quite often, lobbies like trade unions are saying it's too long. You know, let's get it out of the way. Let's get it done properly. But does that mean we have to take 90 days? So that could be quite interesting. Consultation at the moment of introducing fees in employment tribunals. This is quite a big thing, okay? So they're talking about next year. If people go to tribunal with a claim, they're going to have to pay. And they're talking about 2 levels of payment. Level 1, issue fee, i.e. when you lodge the application, £160. Hearing fee, if you go on to a hearing, £230. Level 1 claims are talking about things like Wages Act, notice, holiday pay, so on and so forth. Level 2, issue fee, £250. Hearing fee, £950. Okay? Level 2 claims, it's about unfair dismissal, discrimination, more complicated claims. Okay, so from an employer's perspective, does that sound like good news? There's a lot of debate at the moment. It's going to deter people from going to tribunal. Okay, so far so good. Let me play devil's advocate. People can't go to tribunal because they can't afford it. What's happening to them? They're still in your workplace. Guess how happy they are. Now, looking at some of the flip charts up there, which Patricia was facilitating, and some of the post-its, on the internal one, there's quite a lot of stuff about not just developing staff, staff engagement. In fact, there's one made me laugh. It's just an issue, staff. Full stop. But engagement of the workforce. That's not just commitment, it incorporates motivation, it incorporates clarity of the purpose of the organisation. How's that going to be affected if we've got people sitting in a workplace with what they consider as a genuine claim, but they haven't been able to have that claim heard? So that might put a bit of pressure on your internal management procedures, like supervision, grievances, absence management, so on and so forth. Okay? Employment tribunal rules. That's basically a set of proposals by Judge Underhill to try and put the employment tribunal system's house into order. There was a review which said it was too complicated, too complex. So there are some changes afoot there. Okay, lovely, yeah. Very quickly then, just to finish off with a few things. Other proposals, fit notes. I'm sure we're all familiar with these from two sides of the fence, okay? They are intended to be computer generated as from next year. Compensated no-fault dismissals. Okay, so there's a proposal there to make the dismissal process simpler, quicker and clearer. Now this is really designed for what they call micro businesses. Not sure it would necessarily impact on you. But no fault dismissals, the word before that, compensated. It's going to give small employers the opportunity to cut out all those troublesome procedures that people like I talk about a lot. But you're going to have to pay a fee potentially to do it. There's a couple of things there, looking calls for evidence on employee ownership. Actually, some of this came from, I think, was it George Osborne at the Conservative Party conference recently? Suddenly a big announcement about the benefits of employee ownership. Again, I'm not sure how this is going to affect you, but this is based on a study which showed businesses where they're employee owned are more stable. Okay. Next. Just a very quick reminder of the proposed change for holidays. And this is just really reinforcing they're looking at carrying over or introducing the right to carry over up to 4 weeks of statutory annual leave. Just to reinforce a few points here, really for me a lot of this comes down to the rules and procedures you've got set up in your workplace, which govern how people can apply for, give notice of the leave they're taking, and deal with issues like sickness. Now, there's some of the specific things I can deal with if people come and see me at lunchtime. Okay? It's just a couple of cases, really. I've just put a couple in, thought it might be of some interest. This one is quite famous in HR circles. This was about a partner in a law firm, I think, who was made to retire at 65. So I've included this because it illustrates, of course, the recent employment law change from a year ago, which you're familiar with, abolition of the national default retirement age of 65. Okay? So the practical question for you now is, what do you do with your 64 and 65-year-olds? Particularly, as some of the post-its up there, we're talking about issues of developing people, performance management, in a changing environment. Your environment, to me as an outsider, appears to be turned upside down. There's a lot of key changes, isn't there? Okay? So I'm going to leave that as a rhetorical question. What do you do with those 64, 65-year-olds? Because you can't retire them anymore. Now, one option which this case has established a possible precedent for is you justify a normal retirement age for your workplace, which happens to be 65. My recommendation is that's going to be difficult. However, this company was able to justify it on the grounds of things like succession management, planning ahead, career development, the career path for associates up to partner status. So it's a debate worthwhile keeping your eyes on, I think. I'll give you an answer to my rhetorical question. People who are 64, 65, 66 and there's performance problems, you deal with them in the same way you deal with everybody else. You have the right under law to manage performance, attendance, conduct. Okay? And the last one. I've just put this in because this is one of the cases that is driving this whole issue of still accruing your rights to statutory holiday while you're on sick leave. This case and another has introduced a bit of complexity in terms of how you manage it, because one case says the individual must put in their request for leave in the leave year that they're sick. Otherwise, they lose it. You know, it's that old phrase, use it or lose it with annual leave. Your leave entitlement exists for a fixed leave year. Second issue coming out of that, is there a duty on the employer to inform the sick employee that legally they still are accruing statutory annual leave? This case said no. Another case said yes. But that's the joy of employment law and employment cases. My recommendation to you is, if you're dealing with people on long-term sick leave, communicate with them, keep in touch. Part of that should be now managing their leave rights as well as looking at diagnosis, return to work. Okay? That's it. So, lots of good news there for you. I'll finish with a quick statement. Employment law, there is a lot of it. It's complex. My view is, with appropriate advice and information, it can be managed quite straightforwardly. And often that's a test of your policies, procedures, management skills. Okay?
Thank you very much, Simon.
I've got to say, I don't usually get applauded for going through employment law.
Look, we've got a few minutes for some questions. I'd just like to start off and ask you a question about partners retiring.
Yes, okay.
Now, I've been watching that space, and there's been some interesting case law, hasn't there, about partners who aren't employers, who are, the owners of the business. So, what's the situation when a partner doesn't want to retire? 65 doesn't want to retire, but the other partners would like that partner to retire. I just would like to understand what your...
Okay. Well, the Selden case is basically saying the partnership, which is the employer, would need to be able to justify a normal retirement age for that practice of 65. Now, what justification means in employment terms? Broadly speaking, two things. One, that you can demonstrate a genuine business reason. And actually, the Selden case took it a bit wider than that and said a reason that's in the public or community interest. Now, I think that would be applicable to general practices myself. Second thing is that is a proportionate means of achieving it, i.e. the normal retirement age. Now, the other partners would have to meet that challenge. Now, my experience of employment tribunals is the high jump bar for justification is almost always a high one, okay? It can be done, but you'd have to show some really strong business reasons. Well, performance reason isn't retirement then. You're not retiring them, it's a capability issue, potentially. You need to manage that and go through reasonable procedures, but capability in employment law is a potentially fair reason for dismissal. So actually the means exist to deal with people who are performing unsatisfactorily. And I can talk to people about the details of the procedures behind that.
Yes, if you've got your own partnership agreement that states normal retirement age is 65, surely they've signed up to it right at the beginning when they joined the partnership.
Right. Well, first of all, generally speaking, the impact of statutory law will override contracts if the contracts contravene it. Okay? Now, the issue with partnerships is a little bit different than the issue of employment rights for staff. So that might be something you want to take specific legal advice on. But remember, this case of Selden, there presumably was a partnership agreement there. It was used. Selden went off to tribunal or the courts to challenge it. So I think the potential is there to challenge even partnership agreements on this specific issue. But again, I would say if you've got a specific situation you're dealing with, take specific legal advice, solicitor.
There,
Yep.
it can be as many as 50% of practices that have no partnership agreement, in my experience.
Ah, right. Okay. Well, that's an interesting observation. Yeah.
There's a question down.
We'll come to you.
Just a quick question on paternity leave.
Yes.
When the mother has had her statutory period, you said that the remaining 34 weeks could be shared.
Yep.
Can that be shared in any ratio?
Well, no, because the first 4 weeks, part of the proposal says there'll be 4 weeks for each parent. And then after that, the remaining 31 weeks could be split in any way, as far as the proposal suggests at the moment.
Like 32-0?
Potentially, but again...
Either way.
Yes, absolutely. But again, watch this space. These are proposals at the moment, okay?
Under partnership law, it doesn't actually affect the partnership agreement in the same way as it affects employment law.
No.
But how is it, what are the chances of a partner challenging in a court of law and saying they're being discriminated against if they go on to maternity leave and then dispute what is actually in the practice agreement?
Well, we talk about discrimination law now, swept up under the Equality Act fairly recently, 2010. Partners do have a right to bring a claim of discrimination. Discrimination law is different in its scope than most other employment law. So partners could potentially bring a claim, but it's going to depend on the circumstances, the nature of the partnership agreement, for example.
If you only allow as much agreement to end of, how challengeable is that?
Right, oh, that's a good question. If I was a solicitor, I'd say a lot of things are challengeable in that people have got the right to go to tribunal with it. But again, you're going to have to look at the impact of the partnership agreement and look at that against the requirements of the Equality Act. They may have the right to challenge it. Okay. And again, I think it's about taking specific legal advice about the partnership agreement that's in place, if there is one. Yeah.
I think we'll have to move on. And just to remind you that Simon will be here for anybody to go and have a chat with, you know, any specific issues that you've got. Do use him, great resource. But thank you very much, Simon. I'm sure we'd like to thank you for...